We are live.
Okay. Good morning. This is Senate Judiciary. It is Wednesday, March 22nd, and we're taking a look at draft 2.1 of S91, the bill having to do with insanity and competency stand trial. And we're reminded that insanity is a legal term here. And it's his competency has to do with ability to understand the nature of your actions. So Eric, if you want to walk us through this new draft.
Yes, certainly can. Good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel.
He's once a year. I was every twice a year. Director Symposium and our annual training conference. You can introduce yourself, please.
Whoever that was. Go ahead, Eric.
Thank you. Yes, here to walk the committee through the new draft of the strike-all amendment to S91, an act relating to competency to stand trial and insanity as a defense. This should be version 2.1 from 4:21 p.m. yesterday. Senator, do you want me to share my screen or?
Yeah, why don't you? I think it's easier for those on Zoom and other.
Sure. Let me try. I don't know if you recall, but last time I tried to share my screen, it didn't work. And in the meantime, I had IT look over my iPad. Hopefully, we'll see. The problem was solved.
Hopefully.
Yes, hopefully. So let's see. Says I'm sharing screen. So let's see if this works. Success. All right, so as I mentioned, this is version 2.1 of the committee strike-all, and the only changes between this draft and the last draft are toward the end of the document. So if you starting on page, let's see. Starting on page 10. So the first one's a technical one. I didn't even highlight it, but you remember Senator Baruch mentioned that there may have been an inadvertent meaning in the way that the competency restoration program plan language was structured. So I just rearranged it so that the departments and entities that are receiving the report come first before the description of what the report is. So it says Department of Mental Health and Dale shall report to the governor, Senate committees on judiciary and health and welfare, et cetera, a plan for whether a plan for a competency restoration program should be adopted in Vermont. So it's just a restructuring of that sentence. So it wasn't ambiguous as Senator noted last time. So that's purely grammatical, that change to that sentence. The new sections are the next three sections, 8, 9, and 10. So you remember the discussion had been, I think, where the committee decided it wanted to go was, and this is the issue of whether or not other mental health professionals be able to do the psychiatric evaluation of a criminal defendant whose competency and sanity is at issue. Right now, required to be a psychiatrist. Committee's been discussing, should it be doctoral level psychologists, that sort of thing. So the way this is set up is that you have temporarily added subsection D on page 10, that's line 16 to 19. And I say temporarily because I'm going to jump ahead just for a sec before we come back to the language. You'll see, I should say it has a deferred effective date rather than, it's not a sunset, it's a deferred effective date. So section 10, you'll see lines 13 to 14. Section 8, which we're about to talk about, doesn't take effect until July 1st, 2024. So there's a deferred effective date. So for now, it doesn't take effect. Now, all right, what is the language that's going into effect on July 1st, 2024? It's this provision that permits the psychiatric examination that I mentioned to be conducted by a doctoral level psychologist trained in forensic psychology, and licensed under chapter 55 Title 26. That's the OPR statutes that specifically provide for licensing of doctorate level psychiatrists. So, as I mentioned, this doesn't take effect right away. What happens in the meantime is Section 9. In the meantime, the Justice Oversight Committee studies the issue and thinks about, well, who is it, if anybody, phrased the same way as the competency restoration program, who, if anybody, should be added to the current requirement that a psychiatrist only conduct these evaluations. So it tasks Justice Oversight with reviewing whether Vermont law should permit competency and sanity examinations of defendants under this law to be conducted, in addition to psychiatrists, by doctoral level mental health providers, psychiatric nurse practitioners, or any other professionals. So it's phrased broadly, I think, as the committee discussed, because at this point in time, it's not making a decision, it's just asking Justice Oversight to look at it. You know, they decide that some of these folks should be permitted to do it, they may decide to recommend that they shouldn't, but it leaves it open so that they can take testimony, look into it, talk to the interested parties, whatever work that the committee needs to do in order to make a recommendation. And the recommendation is going to be in subsection B. You'll see, actually, I should say before I get to that, well, the recommendation is going to be very specific because it's going to be whether or not to amend this section of law that is going to be going into effect next July. So you see, because the way the law that would go into effect next July says examination may be conducted by, it's very specific, doctoral level psychologist trained in forensic psychology and licensed under the OPR statutes. So that's a very specific category. Justice Oversight is going to be looking at, should it be more people than that? Should it be broader? Or should it be anybody really other than psychiatrists? Their task, their charge is broad. So what the sentence you'll see on lines 5 to 7 says, their recommendation under subsection B, that's in other words, their recommendation is going to be whether that language should be changed or repealed or modified or leave it as is, whatever it is, whatever they recommend about who should be able to conduct these evaluations is going to be an amendment to subsection B. That's all it's going to be. Either repeal it, add some people to it, keep it as is, whatever they decide to recommend will be proposed language.
If they do nothing,
right?
If Justice Oversight kicks the can down the road, this becomes the law.
Exactly.
Okay.
Exactly.
But she won't let that happen.
Well, we might.
Who's on that, Senator? Says I know I am.
I am.
So it's me, you, and
I'll be Alice Emmons and Butch Shaw are from the House, and then usually Jenny Lyons has been on it from Health and Welfare, and
there's three of us, right?
Phil Baruch was on, but I think he's taken himself off. And there's, I think, 4 members from each body. Teresa Rick was a member from the House. And who was the other?
Lalonde.
Who?
Lalonde.
Martin. Well, Martin will be on it, taking what's her name is, Maxine Red. I don't know if Butch will be on it again, because he moved over to transportation.
Hey, I was just pulled up the list. It says Trevor Squirrel, I think, is on it too, right?
Oh, yeah.
Yeah, that's right, yeah, from the probes.
All right.
Who's from the Senate?
Yourselves and Senator Sears and yourself, Senator Norris, Senator Lyons, Senator Rom Hinsdale, and Senator Renner.
Oh, they're listing Representative Bragg. She's not on there anymore.
Yeah, this may be wrong then, because also,
The Senate is right, but in the House may be wrong.
Yeah, definitely.
Good. So, anyone who would like to make comments on this bill, Senator, we just promoted you. Thank you.
I got promoted.
No, so Matt L'Oreal got promoted to the Senate.
Funny, I didn't feel that way.
Is that a promotion?
Called him Senator Valerio. Well, somebody was talking to me about you running for the Senate.
Yeah, well, I can't take the take that way. You want me to do it from here?
Yeah.
Should I keep the language up, or what would you prefer as far as?
Oh, you
share the screen?
You can keep it up, and yesterday, unfortunately, I had to be in court. And if this is ultimately going to be the version that you vote on, I just wanted to make two other comments besides and they won't take long. Eric, on page 7 of 11, line 16, it's that subsection B of 4817.
Mhm.
I mean, I get what it's trying to say, but it's written really weirdly. And somebody might want to bring that up, but I just wanted to.
Yesterday, we were discussing, and maybe this is off, that the thought had been that you might want both provisions there because the parties might agree. Like in the existing law, if the person is a competent state child, presumably it doesn't always reach a court finding. Am I right? Is that correct? And then,
Well, if the person is incompetent to stand trial or is found incompetent to stand trial
right.
by preponderance, I don't know what that.
Well, the intent was to cover both situations where there was a court finding and where the parties just agreed that there was incompetency.
You might want to put something like if the parties agree or stipulate to
Right.
Incompetence, because that's not really clear. It wasn't clear to me as I read it.
Right. Would it work? Just one last suggestion. Do you even need both then? Could you just change the existing phrase to just say found incompetent?
That was what I thought was going to.
Okay.
But it read oddly to me, and I wanted to bring it up.
Okay.
There I go, where I can't see what they wrote. I did want to make one final comment on if this is going to be a version that the committee votes on page 9, sub C, starting at line 17. This area for me, just so I want to kind of go on the record and put this sort of jurisdictional and constitutional issue in your head before you decide to vote for it, to bring it up again. From a jurisdictional standpoint, this doesn't make any sense. This is an area where if there's a finding of incompetence, the jurisdiction over both the person and the subject matter gets transferred to a different statute. It becomes a civil matter. It also goes into family court. So to keep jurisdiction over the person who has been found incompetent and the subject matter, which is under the mental health statute, subject to the jurisdiction of the criminal court, which by virtue of the finding of incompetence has already been determined that the criminal court doesn't have jurisdiction over this person. Rather, it is now under the civil under a civil order of hospitalization or non-hospitalization. It's not appropriate to do that, and I don't think it's actually legal. I would refer you to the testimony that followed mine initially by Judge Zone, who agreed with my analysis of it. And then, while he did not opine on the constitutionality of subjecting somebody to the jurisdiction of the criminal court while they've been found incompetent, did cite U.S. Supreme Court case law that says that is not appropriate. And if you can't read those tea leaves, well, I don't know exactly what to tell you. So I think that you're gonna have a problem there. And I'm pointing it out so you can do what you will with it. But I think you're gonna have a problem.
Isn't that what happened in the case in Bennington County?
Well, the issue is a matter of practice and what happens. So we have to have a case that is aggrieved by it. Prosecutors handle this differently, and many of them dismiss those cases. And so the conditions of release don't apply, and then there are some that keep them there. So you end up with somebody who is down under order of hospitalization or non-hospitalization, who then acts out again, gets another disorderly conduct or simple assault, and while just being found incompetent is now back in court on either violation of conditions of release or a new charge when they were just found incompetent, which number one, makes no sense, and number two, wastes everybody's time. What really should be done, this suggestion that I made, is that Department of Mental Health should have the ability and a more robust ability to enforce those orders of non-hospitalization. Is not, and because what you're basically saying is, well, you just came through on and we just found you incompetent, but you're only incompetent for this case. What you're saying is the person is incompetent, not the case is incompetent. So if you end up back in court a week later being charged with another crime when 2 weeks before you were just found incompetent, it doesn't make any sense. And it's one of the things that has to be addressed and was talked about during S3 and the suggestion that I made. I don't know if my memo regarding that ever made it to any of the senators here, but was to build up Department of Mental Health's ability to supervise in the community the people who are under orders of hospitalization, non-hospitalization, and allow them to intervene based on those orders to be reviewed if they need to be in a more restrictive environment. That is the venue to do it, not the criminal court when it's just been found incompetent a couple of weeks earlier on a different charge. So that's, I'm just telling you where you're going to see a problem at some point when the right case presents itself from the defense bar's perspective. And I think that Judge Zone, when he followed my testimony, he agreed with what I was saying. So I'll now skip on to this last portion that you're talking about, the section 8. The backlog in these competency evaluations right now is huge. We need this help now. We need, and as of right now, we've used doctoral level psychologists, whether they're PSYDs or PhD level psychologists who have this training in forensic psychology and are able to administer the various tests and apply the standards. We use them now in court as experts, either to support or to rebut the psychiatrist's initial evaluation. We already use them. The only thing that they don't do is make the initial evaluation as to whether somebody is competent. We need the help now. We don't need the help. I mean, we probably need the help even more a year from now. But I'd like to be able to personally, and I think the whole system would like to get at this backlog immediately. And I don't think there's any real dispute that PhD level psychologists and PSYD doctoral level psychologists who have this training are competent to do the work. It's just that the statute historically has relied on psychiatrists. If you want to add in other people down the road, you might want to look at that. I'm not really in favor of that. I like to keep that at the highest level of people doing the evaluations when a liberty interest is at stake. But we need help now. And so I would suggest that, you might want to look at, do a sunset, see how it goes for a year, but don't wait a year. We've got to get through these.
So we could just reverse the section 10 verbiage to section 8. This act shall be repealed effective July 1.
Do a sunset or something that.
Yeah, that's what you do.
As opposed to delay, and then the committee can look at it. Justice Oversight can look at it, but we are in dire need of trying to get these things done, so we're not waiting 6 to 8 months.
You have 3 suggestions, Senator.
I think, I'm curious, what was the original rationale for having this take effect a year from now? Is anyone
worried about? We were doing a study to determine whether they should be able to or not. And so we wanted to force the issue.
We already use them. It's just, they can't do the initial evaluation.
Yeah, I mean, I would support making section 8 take effect upon passage. And I don't even know that a sunset is necessary, but I'd support having a sunset as well. But I mean, I think it makes sense.
Study it in the sunset and study with it.
Yeah, I would support having it take effect upon passage. The other harder nut to crack, I think, though, is what was mentioned earlier regarding page 9, line 17 through 20.
Yeah.
I don't have an answer. I think that's just the harder one to resolve.
Well,
By the way, I don't mind that prosecutors, victims and that are getting notice of, somebody's not doing well in the community, and then the notice issues are not an issue as far as I'm concerned, but the forum and the subjecting somebody to criminal liability when they're just found incompetent doesn't seem to make sense.
okay, let's hear from some of the other folks that are about the three things that Matt raised, and there may be other issues to be raised. And I wonder if there's anybody who'd like to comment on any of those three issues or any other issue.
Should I take my screen down, Senator, Sears, so you can see?
Yeah.
Might be up there.
Judge Zone, I can see your hand.
So, Tom Zone, Chief Superior Judge, I would comment on the three topics that Matt touched on. If we look at the first one, which was on page 7 about the competency, I think that even where the attorneys, the state and the defense agree that a person is incompetent based upon the report under our statutory framework, I still think the court makes a finding, but the finding is not based upon a contested hearing. The finding is based upon the agreement. What it says is the relevant under 13 VSA 4816E, the relevant portion of a psychiatrist's report shall be admitted into evidence as an exhibit on the issue of the person's mental competency to stand trial, and the opinion shall be conclusive on the issue if agreed to by the parties and if found by the court to be relevant and probative on the issue. So I emphasize the word found because I think the court still has to make a finding that based upon what the court has been given, the individual is incompetent. Again, that finding may be based upon the agreement and the statutory language, but I still think it's a finding. Because that is the building block for everything else. Once someone is found to have been incompetent, then we go to hospitalization hearings and further under the statutory framework. So I think that if the section does just say a person shall not be tried for an offense if the person is incompetent to stand trial or has been found incompetent to stand trial by a preponderance of the evidence, that would work. I don't know that you need both in there, that first part under lines 15 and 16, because I think they are found still.
Okay.
As to on page 9, the commitment, the language on 17 through 20, and then on page 10, where it talks about conditions of release continuing, Matt mentions jurisdictional and constitutional areas. I want to be very clear. As I said before, and I'll say it again, I am not opining on the constitutionality of this. I simply want to identify that it, as Matt said, he indicated that there would be constitutional concerns raised. And I just want to point out that I think that we all have to recognize that is something that will have to be addressed in the courts. And it is something that the courts would have to determine if a case does come before them. So I can't opine on it, but I did note at least one case where the Supreme Court talked about the relationship between criminal commitment and civil commitment. And that's going to be a decision that the Supreme Court has to determine. As to the issue of psychologists in Section 8, I concur with Matt on that. I think that we need help now. I reached out to a gentleman who is a consultant for the National Center for State Courts. I asked him about psychiatrists and psychologists and where they can perform their duties. I was told by him psychiatrists were eligible to conduct competency evaluations in every state. while psychologists were allowed in every state except Rhode Island and Vermont. He said this is dated from several years ago. However, he believes the trend has been to liberalize evaluator qualifications and not go in the other direction. As Matt was talking, I actually just grabbed one of the states that was in a chart that I had, and it was Kentucky. And they say psychologist, and for instance, they say that a psychologist can do it. And then they even had the definition of psychologist. It says a person licensed at the doctoral level pursuant to KRS Chapter 319, who has been designated by the Kentucky Board of Examiners of Psychology as competent to perform examinations. So that's how Kentucky handled it. That's just one example, but I would concur we need to broaden who can do them, and think that we should do it sooner than later.
I think Senator Norris has a question.
Yes, good morning, Judge Donay.
Good morning.
I'm certainly not saying I'm opposed to this whatsoever, but I was just curious as to the lack of a better term, the bar that's set as far as the courts acknowledging doctoral level psychologists when they come into court to testify. Do they have to be identified as experts, or has the court addressed that situation? Or someone just comes out, so I just graduated, I'm ready. Is there a certain bar for this, or what do the courts do with that?
Well, in order to be an expert, there's one area, for instance, with training, education, those areas are places that people can be identified by experts. And so when someone comes before the court, if a party is advancing them as an expert, the court has to consider their qualifications and determine if the court's going to find them to be an expert. I suggest that when we're looking at competency evaluations, if we look at how they're currently done, that will inform how this would play out. The court does not choose the evaluator. The Department of Mental Health does. So right now, the Department of Mental Health is the entity that is charged with finding the psychiatrists and finding the experts to do it. So I would suspect, and I would suggest that if the legislature adopts this change, that would allow the Department of Mental Health to be able to operate and find the people who meet the qualifications that the legislature may set.
Thank you.
I think that's kind of a no-brainer that we should change that. To hear from both you and I'll wait to hear from Jack McCullough and Karen Barber, but from DMH. But I think you put it well. We need help now, not a year from now. So I would concur with that. The one place where I'm going to disagree with both you and Matt, and maybe, I don't know what's constitutional, what's not constitutional here, is on page 9, line 17, then going over to page 10 to lines 2. If we don't have some control, this is what has communities in an uproar. And, maybe the Department of Mental Health needs to build a community-based programming. But, I saw an article in the Bennington Banner about somebody in Brattleboro, like 100 times coming before the court for various infractions, clearly problematic. And, this next step is to work with pathways. And although both parties kind of agreed that pathways probably wasn't going to work. It's, I think, frustrating. And then we have the case in Bennington where both, I think, the victims and so forth need to have this available to them, that the bail, that he was held without bail in a murder case and found not competent, but you still have the fact that that young lady was murdered. So I guess, we'll let the Supreme Court decide if they need to. But, that's where I fall down on that particular case. I think you make good points about the other issue in terms of it is the court that finds competency, not necessarily it's based upon the evidence, obviously, but preponderance of the evidence. So those are my comments on all three items. I'm gonna go to DMH and then Jack McCullough. And Jared Beyond, if you want to speak on behalf of the state attorneys. Karen?
Yes, good morning. For the record, Karen Barber, General Counsel for the Department of Mental Health. I don't have comments on 1 and 2. I did just want to touch on number 3, which was the evaluators. We're fine with having it go into effect upon passage. I just do want to set expectations. We only have one right now that we contract with. So, we can put out, depending on whose responsibility it is to do these evaluations, we can put out a bid, an RFP to seek more evaluators. But I do just want to set expectations that we don't have a bunch of people right now that could all of a sudden do these evaluations. It would be a process, but we don't object to the language.
Well, you never know. There may be somebody in New York that could do cases in southwestern Vermont or on the border. We don't know, they may be eligible.
Yeah, absolutely. Most Innovatel evaluators are out of state and they just have to get licensed in Vermont. So that's absolutely an option.
My wife has to visit a neurologist from Massachusetts because we can't find one in Vermont nearby that can see her. So, yeah, it's just is what it is. Other comments, Karen, or that?
No, that was it. Unless you had any questions for me.
Jack McCullough from Vermont Legal Aid.
Yes, thank you, Mr. Chairman. I just have a couple of points to make. We do not have a concern regarding the who is going to be responsible to do the competency evaluations. I think it's very good to have the legislation specify that it be a doctoral level psychologist, because there are many levels of psychologists and therapists licensed and registered and rostered and so forth in the state of Vermont. And so having that clarified is very good. And I agree that there's a serious problem with how long it takes to get forensic evaluations done. I agree with Judge Zone on the observation about getting an order that the defendant is incompetent. It's yeah, and it would actually, even if there is an agreement that between the prosecution and the defense that the defendant is incompetent, that does not take effect until the court enters an order saying that the defendant is incompetent. And from our perspective, it would clear up a small problem for us, because in some counties, it seems that we wind up getting appointed to represent the defendant in a criminal case when there's a when there's a report filed that says the defendant is incompetent, even if there's not been determination by the court of incompetency. And so that would be helpful for us. The only other thing that I think it's worth pointing out, and it's not really even in this bill, but there's a continuing undercurrent and idea that orders of non-hospitalization are useless because they cannot be enforced. And I just think it's important to correct that. There is nothing either in the law or in the legal system that prevents orders of non-hospitalization from being enforced. To request enforcement of an order of non-hospitalization, and it would typically be a request to do what's called revoke the order of non-hospitalization. All the Department of Mental Health has to do is file a request in the relevant court, and the courts in the mental health proceedings are not that busy that a case like this could not be brought on for hearing within 2 weeks in any of these courts, Wyndham, Washington, Rutland, even Chittenden. Those cases could be heard within 2 weeks if this Department of Mental Health asks the court to revoke the order of non-hospitalization and asks the court to get the case scheduled. And we would certainly do that. And we would defend the case, but it could be brought on for hearing for the court to make a determination very quickly. What I think the real problem is not getting an order of non-hospitalization enforced. The real problem is that the community resources for treatment and housing are so inadequate that that people who are on orders of non-hospitalization do not always get the services they need, and so they may fall out of compliance. They may lose contact with the people who are charged with providing them services, and that's where we get into problems. And I am aware of the story in the Bennington Banner the other day, and there was a good bit of discussion in court at that hearing about the inadequacy of services that we have the ability to provide. And so I think we really need to create a much greater pool of services, which means a lot more money to do that. But if the state ever wants to get a case revoked, they can get it heard very quickly. They're not doing that, and I'm privy to the decisions within the Department of Mental Health, but we're ready to do those cases when they're filed. And that's all I've got. Thank you.
Thank you. Regarding your last comments, I couldn't agree with you more. And Senator Kitchell said it best yesterday in Appropriations Committee about our tendency to start new programs while at the same time starving existing ones. And mental health is certainly one of those areas where we're not providing the services that we should be to the designated agencies, but also those community-based programs that are designed to keep these folks out of trouble. And I couldn't agree with you more, but by the same token, I stand by what I said about that particular section is important to me anyway, personally, in this bill. Thank you. Are there any other comments from anybody about this draft?
Yeah, I have one, and it may be, I'm sure it was something that was discussed when I wasn't here, but bottom of page 3, in line 21.
It was not discussed. It's bottom of page 3.
So it says a motion for an examination shall detail the facts indicating competency, blah, 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 and shall certify that the motion is made after the moving party has met with, and now it would say, or personally observed the defendant. I'm wondering, is it attempting to make a distinction between physically meeting with somebody and observing them over, let's say, Zoom? Or what is the need for the or met with or personally observed? Because it seems like they sort of do the same thing.
I think, and I'll let Pat and Jared also comment this, they'd like to, but my understanding is that the court and the prosecutor can also make a motion for one of these evaluations, examinations, but they don't ordinarily meet with the defendant. They observe the defendant, and though they can make the motion based on their observations, but to say and met with would inadvertently preclude them from making a motion.
I see. So because they've been in court, but they haven't. Okay.
Correct.
Understood.
They wouldn't meet.
Got it.
So Jared Bianchi has comments from the state's attorney. Jared?
Thank you, Senators. I just wanted to briefly revisit page 3, line 8. It says that the state shall pay, and I know that we testified about this and there was some conversation, but I did just want to flag that because we're talking about a system where most of the parties are state entities, that looks like it could be an area that could create confusion. And because I believe that other provisions in statute already address who pays for the necessary expenses of an indigent defendant, I think that is unnecessary surplusage that could cause confusion. And I think that you could just have the period be after the phrase moving party on line 8. I also know that there has been some conversation about the 4820C amendment. Just wanted to share that, it is not our position. We don't share the Defender General's concern about the constitutionality of that provision any more than we would be concerned about appropriate filing new charges based on new conduct for somebody who in another docket had been deemed incompetent. It's really important to remember that competency is a fluid concept and it can change day to day, week to week, month to month. And so it's really going to be important that we're assessing that in each case and in each docket. And we think that, to the extent that there is an agreement, it's rather a disagreement between the parties about whether that section is infirm. We agree with Senator Sears that the courts can resolve that disagreement and are equipped to do so. So if there are any other questions, I'm happy to answer.
Any other questions for Jared? Okay, thank you, Jared.
Thank you.
Okay. So I guess there's pretty generally agreement that changing the effective date, putting a sentence on section D on page 10, which is, excuse me, section 8D, which I think Judge Zone and Matt put it well. We need help now, not a year from now. And so I don't have any problem changing that to having that sunset in a year after giving the Justice Oversight Commission the ability to look at it. But I also, hearing that 48 other states use psychologists and other individuals for the purpose of evaluation of competency, certainly makes one wonder why Vermont would be such an outlier when we have such a backlog of getting individuals. So I think that's in a general.
Right, interject for a second, just on a technical, just so no one's surprised with the next draft. So the way I will do that, I will strike section 8. I had it as a separate section when it was going to be a deferred effective date. I'm going to put it right into the statute now. I'm going to put the sunset right in the subsections, the way we're doing things now. That way you'll have to come back and revisit it next year because there'll be a sentence that says this subsection shall sunset on July 1st, 2024. Do you want to strike that or keep it or let it sunset, whatever you decide?
Yeah, so my understanding is that it would still be 2 effective dates. The act would take effect on July 1st, 2023, except section 8 will take effect on passage.
Right.
So you don't want the whole act effective on passage?
Oh, I don't know. That was my understanding of the conversation we were having. I don't know that I have strong
We had
feelings.
to discuss whether it should be effective on passage.
I would just say some of the procedure like this extra busy work of filing motions and certifications is the like we'd have to train on it, and we would probably do that in June. I actually don't even mind the form that I would, that part, it's just certain, it's gonna change it. But the bottom line is that if that's what you want us to do, then I'll have to train on it. So
Judge Zone, you have a comment on this?
Yes, 2 things. One, we have our training in early June, so if that comes into effect, we can certainly have the judges trained on it. And 2, I I don't want to create extra work for Eric, but I do notice, I would note that if you go with psychologists and add that, you have to go back through all the statutes and make sure that the word psychiatrist is replaced with examiner, I would suggest, because right now, everywhere in our statutory framework, it refers to the only type of person who can do the examination as psychiatrists.
He's already thought about that.
Yeah,
Judge.
thanks, Judge Zoney, but it's not gonna be in this draft. That's why I phrase it as notwithstanding any other provision of law. And it just simply says that's who conduct an additional named party who can conduct the initial examination. So.
Thank you. I didn't
Thank you.
just didn't want to have us miss that one.
No, it was considered. Thank you.
Thank you, Judge. Any other comments? Oh, yeah. I think we've settled on that, Eric. You do it the way you think is best.
Yeah. One other thing that you may want to add.
But do you want to make the whole bill effective on passage, or do you want to make just that effective on passage?
Well, that's up to you folks, whatever.
I know, that's why I'm asking.
I mean, it sounds like there's training requirements for most of the bill that would make it problematic for the whole bill to be on passage, but that section 8 should be.
The psychologists, I mean, we know that there are these people out there and DMH is gonna have to get with them and get it together,
I'll take it.
but, in that portion, we can do almost immediately.
We're talking the difference between May 15th and July 1. I don't think it's a huge issue. I think just make the whole thing effective July 1. Since both the judges and the defenders, and I'm sure the state attorney's trained too at some point. In June, I know they do. So that Campbell wasn't available to play golf on June day because.
Or he said he had a trip.
Well, that's what he said.
So where was the fine? Where do we land on that? Sorry, I missed it.
Everything's effective July 1.
Okay.
And then section 8 would repeal in a year unless we do something, or
Correct.
sunset. Okay,
Yeah.
perfect.
Okay, so next issues. Some of the other things that have been brought up, are there any changes that people want to make?
What about the point that Jared made, Senator Sears? Removing, was that already addressed, or the moving party on page?
Whether we should get rid of the language about indigent.
Who pays?
Yeah.
On page 3, line 8.
Yeah.
I take the,
I just asked.
I guess I thought that was stating what was already the case. So I wasn't clear on how that would cause confusion.
I mean, it's part of either the Defender General's budget or the state attorney's reports. Right?
So this is the confusion that Jared has about that section of the Public Defense Act. That is for the necessary expenses of litigation. And what you're trying to determine here is the jurisdiction of the criminal court to even be there. That's why it's, I think it's the Department of Mental Health, actually. The court makes the referral for the evaluation. Department of Mental Health has the contract to do the work. If you shifted, like the requesting party has to do it, then we want millions more that you would shift out of the Department of Mental Health into the DG's budget. There's no reason to do that. And it would also kind of convolute what that section in the Public Defender Act is for, which is the necessary expenses of litigation, not the jurisdictional prerequisite of competence to go forward.
Okay.
So, Matt, I'm looking at page 3, lines 7 and 8 and 9. Are you saying that you, because I think Jared's suggestion was that we get rid of the following clause, in other words, and end with the moving party? But it seems like maybe you're also questioning the first part of the sentence?
Well, I said you didn't, when I testified initially, I said you didn't need that at all. I mean, adding it doesn't add anything, and it confuses things.
This entire sentence?
Yeah, the entire line. If you left it in, it doesn't mean anything except for on, the sanity side of things. That's a whole other issue. Because what you were doing previously, we would evaluate sanity and competence together. Now you want to yank the sanity part out of it, so it's appropriate for sanity to be paid for by defense, which will have some impact, but not a lot.
And that will be the case if we get rid of the sentence.
Yeah.
I guess if we don't need it.
Karen, did you want to comment on that?
Yes, thank you, Senator Sears. I would support Jared's proposal and respectfully disagree that it doesn't mean anything. I think it does. Actually, the whole point of part of this is to move it to the parties to the case so that they are more in control of these evaluations. So that is the point. And so that is why that language is important. So we would agree with Jared that it could end after that, but we think that section should remain.
Deter defense from even asking for it, which isn't going to happen.
Okay.
Take a little look at it. I mean, the implication, I just say for the record, the implication here is that you're going to deter defense counsel from asking for competency evaluations because of the cost, which we can't ethically do. If there's a question as to competency, we've got to raise it, and the cost of it is not going to deter the defense counsel from doing that. So, you know, all I would be doing is asking for millions more in the defense budget to cover what we're already doing.
We don't want you doing that.
Yeah, I already got my, I got other issues.
I know. We haven't met yet.
Yeah.
And I gotta meet with the, you know, maybe I should meet at the same time with the state attorneys and the defender general and the courts. Bring you all in and say, straighten this out.
Fine with me.
Karen, I see you have your hand up and a thumbs up, so I'm not. sure.
I'm so sorry. I don't know how to get the thumbs up off. I was trying to raise my
I thought
hand.
maybe you were agreeing with Matt.
No, I was not agreeing with Matt, and now I can't take the thumbs up down, so my apologies. So I did spend a lot of time on this issue in my testimony the other day, talking about how, in fact, it wasn't at all meant as a way to prevent anyone from getting any evaluations that they need, that simply the Defender General would have the same bucket of money that we do now, and so they can get as many evaluations as they want. It's really about who controls and who is the one responsible, because again, we're just this third party trying to negotiate between different people, and we're not a party to the criminal case. So it makes much more sense for instead to be the parties to the case actually arranging for these things. That has nothing to do with giving them any less money. They'd have the same amount of money we do. It's not at all about the money or cost shifting. It's really about the control. And I'm happy to, you know, I have notes during my testimony. I'm happy to give those, but I did spend a lot of time talking about Matt's point and why we disagreed. So I just wanted to make sure the committee was kind of thinking about that.
Well, let's ask the Justice Oversight Committee to look at this issue as well.
I just want to make one other comment.
I mean, leave it as it is today.
I understand. This portion of this is supposed to be an independent evaluation. Every party has the same interest in not having incompetent people be part of it. So you don't want to have this thing where the defense says, oh, we think our client's incompetent, so we'll go and find an evaluator and we will control the process, because then it becomes like a defense, like insanity or self-defense or any other thing. It's not. This is a thing where all of the parties have the same interest, and so the independence of that, so it's not part of the state, it's not part of the defense, it's not part of the court. Being the Department of Mental Health, it's a completely appropriate place for them to have that. I know they don't like doing it, but it's the right place for it.
Let's leave life the way it is right now and ask the Justice Oversight Committee to look at this. Can we do that?
Yeah. maybe we can do that in miscellaneous still when it comes back or something like that, or I'm trying to edit here, do you want to put it in now? That's gonna slow us down a bit.
Well, it's gonna, the healthcare committee is gonna be looking at this bill anyway.
At 10:30.
Which is gonna slow it down anyway, so I would suggest we, can put that in between, depending upon if the Health and Welfare Committee weighs in on it, we can put it in before second reading. By the time it gets to the floor, it's gonna be passed over, I'm sure.
Okay.
So I think we have time to do it. I'd like to get a vote on the bill itself. If there's any other changes that folks want to make.
I have one thing.
Yep.
And you might want to, I don't think this is gonna, this won't solve any constitutional issue that has been discussed regarding subsection C on page 9, the commitment order not modifying conditions of release. But you may, just for possibly clarifying your intent, that that if there's any ambiguity that creates with other provisions of law, for example, a person who's in the custody of the Department of Health, just start that subsection with notwithstanding any of the provision. Just so that's not going to cure the issue.
No.
A little more indication of your intent. That's your legal result that you want, regardless of where it says anywhere else.
Anybody have a problem with that? Would this be 3.1 or 2.1?
3.1.
3.1.
Yeah.
Do you want some time? You gotta be gone by 10:30. Do we have time to get a?
Yeah, it's almost done. That's why I moved over here.
Okay, well,